welcome to Labor Talks. Today's special guest is Alexia Kulwiec. Alexia, pleased to meet you and
Very
welcome.
nice to meet you, thank you.
Alexia is an attorney on the faculty of the University of Wisconsin Extension. Welcome to Labor Talks again, Alexia.
Thank you.
Alexia, can you tell us a little bit of something about yourself?
Well, sure. I currently am faculty, as you said, at the University of Wisconsin Extension School for Workers, which is an organization that really teaches worker advocacy, labor unions, that kind of thing. My background is labor and employment law. So prior to coming on faculty a few years ago, I've worked as counsel to SEIU Local 1 in Chicago. I worked for some building trades locals in the Chicago area. And so my career really has been in traditional labor law for labor unions.
Okay. Now, do you service the Great Lakes region or are you nationwide?
The School for Workers will go anywhere in Wisconsin. Well, actually, we will go anywhere countrywide to teach labor advocates, labor unions. Our primary audience is Wisconsin, and we do travel everywhere throughout the state of Wisconsin as faculty at Extension.
Sure enough, and I've had some experiences over in Wisconsin Rapids as some of the classes have been put on.
Great.
Wonderful classes.
That was one of my recent classes, yeah.
And I didn't get to go to that one, but still wonderful. So, okay. So Alexia, you do teach about with the School with Workers. Mm-hmm. Please tell us about the makeup and the activities of the School for Workers.
Yeah.
And who can ask the school to design a class, per se.
Great, thank you. So the last answer is actually just about anyone. We do tailored classes, so we will do them for typically labor unions, but we'll do them for nonprofit organizations, worker organizations. We do some trainings that are both labor management. So if folks need, for example, dispute resolution skills, help in mediating disputes, we can do that. We have an engineer on faculty who will do some time study work or sort of, job standards sort of work, and that's also where labor management comes in. So the school is right now made up of 6 different faculty members, and one of the things we think is great about it is that it's such a wide variety of exposure and experience. So we have an industrial engineer, we have a labor historian, we have someone who really has a very strong union organizing background, and we have someone who's an expert in Latino Chicano studies who really works within the Latino community. And our newest faculty member really comes from construction and is really doing a focus right now on bringing more women into the construction trades. So how do we get more women to come into apprenticeship programs, and how can we encourage them to stay?
Sure.
Did you want to review the names of the different faculty members or no?
No, we don't have to do that. That's
Yeah,
fine.
okay.
One of the things that I know we've had in outreaching too is there's been more of an influx of Hispanic-speaking members.
Sure, absolutely.
As well as Hmong or Laos.
Right.
I know that for a fact because I'm a laborer, and we have a wide diversity of those folks, nationalities I should say,
Right.
that come in, and they've been, just like everyone, they've been a strong supporter. And it's not for everybody, but it's a wonderful way to get some more education, I know, especially in their day-to-day working, be they union or non-union for sure. So, but yes. Okay.
So actually, so you wanted to know the makeup of the school and
Yes.
who can schedule something.
Yes.
And I guess I should just talk a little bit about our programming generally. I could do that now or later.
Please.
So the School for Workers operates where we have residential courses held in Madison, Wisconsin, where folks stay on the university campus, and they might be a one-day program, it might be a 5-day program where you can stay and take the classes all week long. So I do highly encourage folks to take a look at what we have to offer this fall at schoolforworkers.org. But we also host a lot of one-day community classes that are open to anybody. We try to hold those throughout the state, and we're
Right.
trying to do more of those throughout the state so that folks in other areas outside, that are much further away from Madison obviously can attend. For example, we do hold a few every year in the Fox Valley area. I just did one in Milwaukee. I've done something up here in Wisconsin Rapids. So we'll do that anywhere. And then we do a lot of very tailored courses where unions or labor councils will hire us to come in and do very specific training, such as grievance handling, Steward 101 kind of work, labor and employment law, whatever. Contract negotiations. Yeah. So we really can put anything together.
Awesome.
Whatever kind of union training folks feel that they need.
Outstanding. Good. Okay. Now, as an attorney on faculty, what do you specifically teach?
I could be a smart aleck and say I teach the law, but
Well,
no.
that would be too easy. That would be too easy.
Well, my specific expertise is labor and employment law. So I do teach each spring a course in just labor and employment law, which is kind of a survey course where we talk about the National Labor Relations Act, wage and hour laws, discrimination laws, a whole host of legal issues that can arise in the workplace. I will also teach grievance and arbitration classes where we're helping people draft, investigate grievances, and take them through the arbitration process. I've several times, both in tailored classes and right on campus, done grievance arbitration classes where we actually have people prepare for a full arbitration, have a labor arbitrator come in and visit us on the last day and hear their case, where the students will get to put that labor arbitration case on. I've been very involved in teaching particularly the legal sections of the contract negotiation cases, the labor law that's the basis for the negotiations that we're doing, the rules that affect union organizing and kind of activity in terms of employees coming together and engaging in collective activity, union steward training, any kind of representational issues.
Good. Okay, Alexia, there have been some very important court cases recently. Why is Janus versus AFSCME so important for workers?
Yeah, well, I'm glad that you talk about Janus' case specifically. So this decision just came out this morning. And what I would say is, and I also really appreciate the way you put it, which is it's very, very important for workers across the board. I've already been hearing some news reports that have kind of trying to steer it as just being about the labor unions. And it affects workers in every industry, I would argue, across the board. What the Janus decision case what the court has decided is that in the public sector, so the case is limited in its face to the public sector, that labor unions and the governing bodies, government bodies as the employer can't agree to a collective bargaining agreement where the union requires that employees pay an agency fee towards their union. The reason this affects all workers, I think, is one, attacking the union's ability to collect agency fees is really a way of attacking employee solidarity and coming together to improve their working conditions. And the reason I say I think it attacks workers generally too is it's a statement and an indication where we're going in the country in terms of our labor policy. And so, I think that we will see additional efforts and have seen previous efforts, towards this weakening of rights of employees. Thank you. Yeah, yes. Undermining employees' rights to come together, engage in collective activity, decide how they want to govern their workplace, decide how to best have a voice on at the workplace, and choose representatives to represent them. And so it's certainly going to have an impact on employees across the board.
And not so much just as in pay and benefits, but won't that also affect possibly safety if they don't feel such a strong connection where I'm supported because I pay my dues, I get the training? They can then possibly opt out of special things that they might need for training and then make them unsafe, wouldn't it?
Well, I think that what it will do is weaken. I mean, if an employer has safety training or a safety policy, I don't know that an employee will necessarily be opt out of that. However, what I do think we will see is a weakening of collective bargaining. So how employees have a voice on the job, of course, is coming together, standing in solidarity, and working hard to ensure that they have certain working conditions, which includes safety, right? It very often includes having some kind of safety council, some sort of joint labor management safety committee that comes together to ensure that working conditions remain safe. So what I think will happen is, as we see a further erosion of employee rights and as the union loses strength as a result of this court decision and other actions attacking workers today, that collective bargaining strength will be weakened, and that will lead to less protections at the workplace. And it's certainly not just wages and benefits. It will include any working conditions. It can include safety issues or hours or rates of pay or how employees are treated on the job site, the whole host of working conditions on site. Yeah.
Sure enough.
Yeah.
And like I say, with the reduction of collective bargaining and employee rights per se, because when I pay my dues, that money, some of that goes to our training fund, which provides training for me as my fellow brothers and sisters. And if we were to lose
see.
that amount in that collective bargaining, at some point, if the coffers are deleted, we
Yeah.
won't be able to offer that training, and then that would fall back on the employers.
Yeah.
And that's where I'm thinking,
Yeah.
well, I'm not paying that, you should do that on your own. And there again, it comes out of the employee's pocket one way or the other.
Yeah, no, I understand your point. That's a really good point. To the extent that unions are paying for the training programs out of union dues,
Correct.
or out of these agency representation fees, which I think training would have been part of in the past.
Yes.
Yeah, they won't be receiving the same level of training from unions if unions don't have the funds to then provide that same level of training. And you're right, that's one role that unions have really been able to have a strong role in, is to play that role, which a lot of employers have appreciated that partnership and embraced that because they do want safe workplaces and they haven't had to do the training themselves. That's a good point.
Right, and then just a quick follow-up there, and with the bigger companies where they might be able to absorb some of those losses, the smaller companies that are just getting started that maybe don't have the security of the years of experience or wealth that the others have attained, I could see where it would definitely fall by the side and
Sure.
less protection. So,
Yeah,
okay.
yeah.
So, and as we talked about the Janus versus ASME, how is that different from the Fredericks versus California Teachers Association?
Yeah, so it's not actually tremendously different. So the Friedrichs, except in the result.
Friedrichs, I'm sorry. Okay.
The Friedrichs case versus the California Teachers Association involved, and then maybe I'll go a little bit deeper into Janus, but it involved an employee who did not wish to pay agency fees to the union. And to just take a step back, I want to make sure that everyone is clear, that what we're really talking about here, right? So typically, the union and an employer come to an agreement, they enter into a collective bargaining agreement, the bargaining unit members, the employees, vote on and agree on the terms of the collective bargaining agreement, and then that bargaining agreement previously would have had language that employees can pay dues to their union under the collective bargaining agreement, or if they choose to not be a full member, they can pay this fair share or agency fee instead. Both the Friedrichs case and the Janus case involve whether that can occur in the public sector, right? So Friedrichs was a public sector case. It involved the California public sector law. Janus is a case out of Illinois interpreting the Illinois public sector labor law. Sure. But the end result is pretty similar. Both are an attack on whether in the public sector you can have an arrangement where the employer is enforcing a contract that requires employees to pay their fair share towards the union representation. In the Friedrichs case, it had been argued, I believe in 2016 before the Supreme Court. The Supreme Court had not yet ruled on the decision when Justice Scalia passed away in March of 2016. And so ultimately, when the Supreme Court ruled in that case, what they issued was a 4-4 decision, as they were missing a justice on the bench, and it just left things in the status quo.
Sure.
Which I should also, just as a step back, the status quo was a Supreme Court case from 1977 called Abood, which upheld the right of public sector unions to enter into collective bargaining agreements requiring dues or fair share agency fees to be paid.
Okay.
So what Janus was sort of another try at overruling Abood. And one thing I'll just say real briefly on the decision is the Supreme Court did specifically and explicitly overrule the Abood decision from 1977 and found that in the public sector, requiring these fair share payments violated the First Amendment.
Okay.
Yeah.
Not good. Not good.
And I guess I just want to say the First Amendment forbids government from abridging or interfering with an individual's speech. And in this case, we're talking about an agreement between the employees who have chosen by a majority vote to have this contract in place that would require these payments to be made.
Right.
So it's not like the government is just saying you have to pay this. This is a contractual matter that was reached in a democratic process.
Correct. Yes.
Yeah.
I do know that we just had one of our agreements, members of local
Ratified.
precinct- Yes.
Yeah.
We came in and We had 878 have 878 members in our local, and over 90% of us voted in agreement.
Great. Yeah.
Of the remainder.
Yeah.
75% of them didn't come in.
Yeah, and I just want to point that out because I think having your union in the workplace, one of the great benefits is to have a democratic method of having a voice at work, right?
Yes.
To help you have workplace democracy. And that's being overlooked, I think, today in the reports so far. I'm hearing about the Janus decision. It's being overlooked that employees have chosen to have these union representatives. If they don't want them, there's a method they can use to remove them. And then, in most cases, they have voted for that collective bargaining agreement to be in place.
Right.
So this was a decision that employees at the workplace made, as opposed to it being a government simply requiring something of its workforce.
Sure enough.
Which I think is a really important distinction.
Okay, thank you. So now the Citizens United has been very detrimental for the middle class. Do you see any glimmer of where we could get this overturned somehow?
Well, I think actually overturning Citizens United is probably, with the makeup of the court, not going to happen anytime soon, particularly in light of our other announcement today, which was the resignation of Justice Kennedy. What I do think could happen is we could see some movement, if there was enough political support for it, to make some changes to election law. So I think that Citizens United suggesting that corporations have the ability to spend as much on elections, that they're considered the same as people. I don't see that getting overruled anytime soon, but I think that we could see some kind of regulations that would perhaps at least balance the field a little bit with some sort of caps on spending or some regulations about equal access, something like that. But I don't think we'll see an actual overturning of Citizens United anytime soon.
Yeah, that's been my fear for years, but it's still there. So, okay.
Yeah.
Now, in what other ways did the Supreme Court decision in this Epic case affect our unions? Can you think of anything?
In Epic systems?
Yeah.
Yeah. So
in Epic case, I'm sorry.
It's okay. Yeah, there was one other recent Supreme Court decision that I think is very important for workers and labor, and that involved Epic out of Madison or out of Wisconsin, but also several other companies. There had been a merger of cases involved here, and what that involved was whether employers could require that individuals, let me rephrase that employers could prohibit individuals from filing claims against their employers as a class action or in collective activity. So the National Labor Relations Board has been saying that the National Labor Relations Act, which protects employees' collective activity, would enforce an employee's ability to file, whether it's a union grievance under a contract, a wage claim with a federal agency, or a lawsuit against an employer, that they would have the right to come together and file that jointly, that employees could come together and file it together. Collective activity is protected by the National Labor Relations Act. So the NLRB has been saying that means employees can file class action grievances. It means you can file class action lawsuits. And there's been a difference among appellate courts, federal appellate courts, as to whether or not employers could prohibit employees from doing that together. Supreme Court in Epic Systems said that that requirement does not violate the National Labor Relations Act. And so for unions, it's a concern because there are certainly times when we file class action grievances that affect everyone.
Sure.
And so I do see a concern with the Supreme Court decision there. But aside from that, where I think we really will see a real impact of this decision is in class action wage claims, where employees file class action lawsuits against their employers for unpaid wages. And the number one reason they do that is lawsuits are expensive and difficult, and from the employer's point of view, one employee's wage claim may be pretty darn small,
right,
but it would never be worth enough to find a lawyer to take it to court,
right,
unless they can come together and combine it. So I think that will be a real problem for low-wage workers.
Okay. Now, the Me Too wave, which gains ground with the court of public opinion, has become a phenomenon. Why do you feel it works in some cases but not others?
I think, well, the Me Too movement, I think, overall is a great thing because it's bringing attention to a problem that has existed for a very long time.
Yes.
Right? Having more celebrity names come out and say that these things have happened to them, sexual harassment in the workplace has been prevalent in certain industries, I think highlights a problem that exists everywhere.
Oh, definitely.
Yeah.
Definitely.
And I think that's fantastic. I think that right now it is a matter of being important in public opinion. So it's as opposed to say like really analyzing whether sexual harassment has occurred at a particular workplace. I think that we're seeing public pressure being put, say, on companies to not have someone like that in their ranks or supervising or in a position of authority at the workplace. And it's almost more of a public relations kind of response than it is really trying to address the problem and sort of improve things at the workplace. But for the most part, I would say I think the movement's a positive thing. It's bringing light to a real problem. I'm hoping it may encourage employers to improve their trainings, their policies, whereas I feel in past years, most employer policies have really kind of been to protect them against liability. And now I'm hoping it may be to try to prevent harassment and improve conditions in the workplace.
Okay, so along that line, we're in agreement there are other policies that could be helped, that not just necessarily what's in place now. There are some other things that could be added to put in place for sexual harassment.
Oh, so policies that could strengthen
The existing ones.
existing policies on sexual harassment? Absolutely, absolutely. I think that, the legal standard, and I'm not going to get into it, to prove sexual harassment is kind of detailed and often very, very difficult to meet.
Right.
And it's not enough. So I think employers can always have policies that give employees greater protections than the floor that the law gives them, right? And I think that employers could also strengthen their policies by making it easier for employees to report harassment, easier for employees to go to someone they feel comfortable with, easier to investigate cases of potential harassment without there being repercussions or without there having to be a formal process, but just trying to improve conditions. I'd really like to see employers improve their trainings and do more respect trainings, more trainings about how to help one another at the workforce if we see something or hear something offensive, as opposed to it all just being done to protect the employer from some kind of claim.
Right.
I'd really like to see more preventive and affirmative trainings being done.
Something along the line of if the person being offended and somebody else sees it, to also say, hey, don't be doing that, come on.
Exactly.
Grow up
right?
is the one I'd like to use myself. And
Yeah.
just say, knock it off.
Right, because if we all together in a workplace respond to what we see and hear, ultimately we can change the culture of that workplace.
Yes.
And now it's not a matter of somebody having a claim against the employer, it's a matter of preventing that conduct in the first place.
Exactly.
Which I think is much more useful to most employees.
We're supposed to work as a team. Let's be a team. We can tell our jokes and stuff, but there's a line. There is definitely a line in the sand, so.
Yeah.
Good.
Yeah.
Okay. Now, Alexia, can you give us some information on your fall programming?
Certainly. So we have several residential classes coming up this fall, and one that's near and dear to my heart is a workers' compensation class. I have that every fall, and I think it's an exciting class because in Wisconsin we do see changes periodically to regulation. We've seen the law change in the last several years, and we'll ensure that folks remain updated on that. And I always have a host of guest attorneys come in who are really experts in the field and teach a good portion of the class. I also hope this year to have someone come in to help more instruct folks not on their rights before it would get to, say, a disputed claim at workforce development. So workers' compensation, we're having a 2-week bargaining class this fall. One is on sort of the basics of collective bargaining, and the second one will be advanced. So one will be what it sounds like, more strategies, preparing for initial bargaining sessions. And the second might be really digging more down into research and understanding the costing of contracts and that kind of thing.
Sure.
I think that we have a time study coming up, which is done by our engineer to really help with sort of figuring out workload in more technical positions. I think that's really helpful. And we're offering for the first time this fall a residential class specific to the building trades, where I want to speak about labor law that's specific to building trade unions and building trade employees, because there are a number of differences. And most specifically in bargaining is different in the trades than it is with other unions. I've had a lot of unions ask for training regarding unlawful secondary activity under the NLRA.
Sure.
And we will be dealing with that. We will be dealing with a little bit of jurisdictional disputes, and also talking more about diversity issues and how to address, that kind of goes together with the Me Too movement, is sort of how to improve working conditions for women in the trades, as well as just sort of having our nuts and bolts labor law. Okay. So I think it's an exciting group of classes. I know we will also have several community classes throughout the state, and again, we always will end up having some tailored classes for unions, so folks can always just give us a call and we'll figure something out.
Okay. Alexia, was there anything else you'd like to add before we wrap up for the day?
I think I just came from a women's conference of women union leaders, and then we had the Janus decision today. So I would just really urge folks, I think, to continue working together and act collectively. And it's more important now than ever that we have this education, that we have these meetings, and that we learn our rights and enforce them.
Definitely.
Yeah.
Definitely.
Yeah.
Okay. All right. Well, our thanks to our viewing audience and to Alexia Kulwiec, who has made today's programming available. My thanks also to the folks working behind our cameras from Valley Media Works, who not only make this show possible, but give us an outlet for our union voices. And a final note, our Labor Talks is on channel 993 twice weekly. You can also use your favorite search engines with keywords Labor Talks and CVC TV to find us on YouTube. I'm Dean Scanlon. This is Alexia Kulwiec. We thank you very much for joining us.
Thank you.
Television is made possible by continuing community support. If you would like to volunteer or make a donation, you can contact us by calling 715-839-5067 or on the web at www.cbctv.org.